Number 103 of 2003.
103
of 2003. Restoration application has been mentioned repeatedly. The matter is not completed.
application. What is the number of the application?
Application 1 of 2004.
2004.
2000, yes.
Fine.
And
What happened? Why it is not?
Another application.
He's saying he has mentioned earlier. Then what happened?
1 of 2004. And that is the application 11.
Huh?
Amendment application.
No. You have.
Both are fine. Both are fine.
Give us the number of the restoration. Give us the restoration number. Yes. Restoration. Get it listed.
Yeah, but the Shubhajit shop.
Give the restoration number. Yes. Take it.
My lord, may I have your lordship
Why you are
kindly?
giving like this, sir? Give on a slip. This is not the way. Please give a proper slip.
My lord, may I have your lordship kindly to mention? My lord, yesterday I mentioned the matter. Your lordship was pleased to direct me to mention today. My lord, with
Yes.
regard to item number 322 of the monthly list dated 1st September 2025. My lord, petitioner number 4, petitioner number 3 is my lord 4 years old and he is admitted in ICCU of the Sisumongol Hospital. My lord, claim in this petitioner, my lord, no retirement benefit, no family pension has been provided in favor of the petitioners, my lord, in respect of the deceased retirement benefits of the deceased employee, my lord, who is the father
Where
of
is
the
the slip?
petitioners.
Where is the slip?
My lord, I am giving, my lord. My lord, item number 322.
Who is
Well,
giving the slip?
My lord, my junior is giving, my lord.
No. Who is there? There is
Well, I am
nobody
giving.
here.
Well, I am giving, my lord, item number 322, my lord. Well, let it
322
be.
list.
Let it be hard, my lord, or Thursday, my lord, your lordship, kindly please, my lord. As
It's a hearing matter.
hearing matter. Epidemic has been completed.
Which year?
My
Which
lord,
is of-
24.
Then what can we do?
My lord, my petitioner, my
Thursday
lord.
upgraded.
Well-
Huh? He's saying he will give. If he gives, upgrade it on Thursday.
Deeply obliged, my lord, deeply obliged.
My lord,
Deeply obliged.
item number 44, 144 of today's hearing has been, it is Sanjay Kumar Jha versus Union of India. Hearing has been of the petitioner has been completed. Only the respondents has been given the last chance to complete the hearing. And he keeps it for order so that it can be completed.
Next, please mention. This is not a mentioning. Yes.
My lord, I'm mentioning one matter. In this matter, your lordships was pleased to reserve the judgment on 16th of June 2025.
Which matter?
It is WPCT 103 of 2025.
Yes, we are aware.
Relates to promotion.
We are aware. Yes.
My lord.
We are aware. Don't worry.
May I hand over the
You may give it. Yes.
There is one matter, my lord, I am mentioning. These matters pertains to overdrawal issues. Now, my lord, a correction was taken out. But, my lord, in the correction, my lord, one sentence is required to be further deleted. That is one part. And in this batch of writ petitions, there were two matters where the overdrawal was done.
What do you want?
My lord, I am seeking, my lord, the correction of a particular order. Only one sentence is to be deleted. and
Order passed by?
Your lordships, my lord. The matter pertains to overdrawal. Your lordships was 8 writ petitions were heard.
No, that we have already clarified.
My lord,
Sorry.
my lord, one line is required.
Sorry.
My lord, and my lord, there is another thing, my lord. In two matters, my lord, therein overdrawal was made. Now, my lord,
Please, you
these are-
file a review. It
My lord,
will
I
not be
filed
listed.
a can application. I filed a can.
All right. The can will be listed.
Can will be listed.
Yes.
I may hand over the.
Give it. It will come now in the next week.
Lordship, this
Give the restoration. List it in this
Lordship,
week
this,
any day. All right. Next week.
Lordship, this matter was due for judgment on 3rd September as per your Lordship's order, but
So?
it's not appearing on the list.
So, why are you mentioning? 3rd September, we have heard it. You are already mentioning. It will come. We have reserved it. And why are you mentioning? Yes.
My lord, application for restoration.
Yes.
Lordship, may I be allowed to mention one matter, Your Lordship, item number 100 of today's list, Your Lordship. Matter pertains to the extent, Your Lordship, that the petitioner, Your Lordship, participated in a recruitment process, Your Lordship, in 2017.
In today's list.
Yes, Your Lordship. But the also,
No upgradation, sir.
so urgency is that, Your Lordship, the recruitment process is about to conclude.
All
Now,
right,
Your Lordship,
next, call the list. Sorry, no upgradation.
Another mention. The matter has been listed in the for orders, but matter is not come in the list, Lordship. Union India versus HON'BLE.
We don't know. You give us slip, we will see. Yes, call the list.
6 months, Lordship, are already, hearing is complete.
Call the list.
Item number 1,
Lordships, I am for the petition. Doctor, I am very sorry, service is not completed.
Service is not required. Sir, address us on merits.
Yes. Lordship, may I submit, Lordship?
Please file. He's saying his file can.
Lordship, may I submit, Lordship? May I submit, Lordship?
Yes.
The respondent, Honda Banerjee.
Ah,
Honda Banerjee is the respondent, Lordships.
yes.
Yes.
You are for the Union of India.
Yes, I am for the union. He has the appointed compensation ground. Thereafter, Lordship, he has transferred his own request to North Bengal, thereafter Kathia, and thereafter Calcutta, Garden Beach, Lordships. And in the meantime, Lordships, he forgo the promotion. And he forgo the promotion, he has got the three financial benefit he has got. Financial benefit has got, but he is claiming the third MSc. And this is the matter of the suppression of fact that petitioner is, before the learned tribunal has not been stated anywhere by whispering anywhere that he is three promotion in earlier, his three financial benefit he has got. Yeah. And according to that, this is a suppression of fact. According to the learned tribunal, will pass the order, MEC is eligible. But according to law, his third MECB is not eligible because he has already has got the three financial benefits. And learned tribunal and has not considered that view because the suppression of fact. This is the merit of the case. This is the merit of the case, Lordship. And another merits are many merits are there. The first, Lordship, is suppression of fact. He has not disclosed that any time he has got the 3 times benefit earlier, and he is claiming the third MCP, and thereafter, at the time of superannuation, he has required the amount, and learned tribunal passed the order to refund the amount. But according to Lordships, he did not follow the learned tribunal, did not understand because the suppression of fact is there. 3 times he has promotion. Financial benefit he has got. In spite of that, according to railway rules, he is not eligible for third MSc. That is the main merit of the case. Thereafter, others merit of the case is there. Lordships. Purely it is a suppression of fact. If the suppression of fact not, and learned tribunal cannot pass such a way. And kindly see the brief facts of the case, and he has stated that 3 times he has got the financial benefit. Never. That's it. According to Lordship, he has suppression of fact and learned tribunal passed the order, and that he is eligible for third MSc. But according to rule, he is not eligible for third MSc because he has got already 3 financial benefits. And at that time of hearing, other matters will come, other merit of the case I will submit before your Lordships. I'm sorry, service has not completed, has not been served. So I am praying, Lordship, 1 week time for servicing the application. 1 week time. Tribunal order. And learned tribunal lordship kindly have me lordship. Why third MEC was withdrawn. That learned tribunal did not disclose the judgment. So why third MEC has been withdrawn? Never is judgment. He has not disclosed that. Because the separation of fact is there. And everything is replied. We have stated everything. Page 90 of reply of the administrative tribunal by the respondent, and reply have stated on all things. And reply page 91, annexure P6, and page 90, Lordships. Everything is clear in the reply. The policy matter of the railway, Lordships, and Lordships, you know that no court will interfere with the policy matter of the government, Lordships. That is well-known judgment of the Supreme Court.
Yes. Let notice be served on the respondent. Serve on 2 weeks.
Yes.
Next.
Manal, 23rd September.
Item number 2.
We are asking to Yes, you were supposed to give a list of dates. I have given already. Already given. He has given you a copy.
Page 101.
It is that case in which you are relying upon some
Yes, yes.
chart which was given.
This issue is not contested that submission was right. My claim is only based of estoppel, my lord.
By basis of the chart that they had submitted.
Because at some point of time you have admitted that this should be my pay scale because I was actually claiming a higher pay scale.
No, but claiming the higher pay scale, any order has been passed,
No, that has been refused in my favor.
refused in the order impugned.
Yes, my lord. The order impugned did not even look into these issues. My lord.
It said,
It just said it is barred by res judicata. It
so
did-
where is the determination? The impugned order is of which date?
It starts from
Third paragraph.
Huh?
at 185.
185, third paragraph.
185.
Related to fixation of penalty and depreciation of expense claimed by the applicant as a subject matter of series of litigation.
Can you give us the OA number?
OA number is OA number is
960. It starts at page 180
OA number 960.
and 960.
2003.
Yes, 2003.
2003. ma'am.
The issue is whether an extra D was submitted by them or not.
Why?
If an extra D was submitted by them, you may be having a case. If an extra D was not submitted by them, the tribunal says it is resorting to a misrepresentation.
My lord will kindly see this should not have been the issue because this is recorded in the judgment. This is a thing whether the chart was at all submitted or not and which chart was submitted, that may not be very conclusive today because my lord, I had relied on a judgment on page 185 which says my lord, if you want to deny something which is recorded in a judgment, it has to be done in a particular manner.
No, that judgment, this annexure D was filed in which judgment? Just please.
So, no, this annexure D was filed in this proceeding, in this OA. Your lord,
No,
kindly
you
see
say that this,
page 186, it also appears a matter of annexing calculation sheets.
there is no such paging in the brief.
One
186 is which page of the tribunal's order?
page 7. my lord.
Page 7, 186. Yes.
So it says it also appears a matter of annexing calculation sheets. The same were not submitted by the respondents and the applicant thus did not come before the tribunal with clean hands. Now, my lord, from the judgment of the division bench of Calcutta, it
So
is
there in this chart was submitted.
there in the first time.
Therefore, we are asking where this was submitted.
So,
where is that?
That is at page 165 in the
No, no.
reply filed by the state.
No, yeta.
Chart. Filed by the.
Please, Please.
ডিভিশন বেঞ্চে যে সাবমিট হয়েছে
Yes.
যেটা করো বার করো পেজ 69 possible
187.
page 71. This is the division bench judgment, part of the division bench judgment. Page 71, the second paragraph. Along with, my lord, ওটা তো দাগ দেওয়া আছে, দেখো কোন প্যারাগ্রাফে এই কথাটা বলেছে 75. Well, we'll kindly read first 71, second paragraph, and then we'll kindly see 75 bottom, my lord. Even on the basis of final calculation.
$75.
Bottom, my lord. Even on the basis of final calculation, last three lines, according to the final calculations made up to 1591, his basic pay as on 1599 was 2070. This may be compared, etc., my lord. So, my lord, this fact that a chart was produced which showed that on 1591 his basic pay was 2070. And I'll also next paragraph, my claim was 2135.
So after the Supreme Court, you have filed 960.
Subsequent, yes, ma'am. No, before 960, I have filed another one.
So after the Supreme Court order 95, Supreme Court 1359, you have filed another one.
Another claiming, challenging my pay scale on the basis of
What happened in
rich
that one?
that was rejected, madam. Just before my Altamas Justice Altamas.
Page 150,
150.
ordering portion,
150.
150. Justice Kobe sitting with Justice.
No, no.
Except
সুপ্রিম কোর্টের এটা তো আলতামাস কবির তার
yes, Altamas Kobe and Justice.
Fif-
Boswell.
ওএ 954 টা আছে, ওএ 954 এর অর্ডার আছে, ওএ 954 after the judgment of the Honorable Supreme Court, I had filed OA 954. This was rejected. I have normally annexed the only the I came up before the High Court against that order
954.
954. 954 order I have not annexed possibly.
Wait, what is the discussion?
Now after this WPST 377,
Then I went back, Miller.
then you went back to the tribunal.
Tribunal.
They
And raised this particular.
no, they must have
one.
passed any order pursuant to their writ petition, then you would have gone, or without their passing any order, you went to the tribunal. After WPST,
I filed it. After that, I retired.
after 377 was disposed.
Yes, sir. After 377 days, I retired.
Yes.
I got my retirement benefits. Then I wrote
No,
to them,
so therefore your pay was refixed.
refixed.
In compliance of the
Yes.
High Court's order, it was refixed,
refixed.
pension was determined and you retired. Then what happened?
Then I kindly see next page. Then I started with my representation.
Challenging the refixation.
I said yes, madam. Even actually challenging the refixation. Same issues, madam. At page 151, 9th July, by this representation, same issues were urged, my lord. Kindly see page 154.
154, yes.
Yes, my lord. Same, I had urged this, my lord. Then I filed 960, my lord.
In 960, the recovery aspect was allowed.
That has been allowed.
So now only the fixation aspect. So therefore, today the only issue is
Yes.
whether this annexure D was a genuine document or not. If it was a genuine document, then you may be able to reap the benefits of the document. If it was not,
Yes.
then you may not.
Calculation sheet submitted by the government, that is the authenticated document.
No, where is annexure D?
Their reply, annexed to their reply, my lord.
Reply at page 165, 4 and 165. Kindly see the page 165 top. Details of pay of the Gurudas Raj as per calculation of the department.
Yes,
Top.
yes.
Then you are also the next page. On next page, last item,
1850.
15.
1850.
1992, 1850.
Yes.
And each
No,
calculation-
1795. As on 1691, 1795.
1st May 1992, 1850, and so far the calculation submitted by the page 167,
That is submitted by the petitioner.
and his calculation shown is 2070.
So that is his claim. He is claiming 2070.
My lord,
The calculation-
why this note, this may not be quite genuine is, if your lordship.
No, no,
Is page one.
page 165 is Annexure D.
Yes, my lord.
So once, if
This is not Annexure D, my lord. Annexure D comprised of this first page and my petition's last page. These are the mistake which I admitted, and
this Annexure D comprises of page 165,
5 and 168.
168. Oh,
So this is what I had filed. So that portion, that particular was not correct, that was admitted by me. I did not dispute that.
then how you can get 2070?
Well, on the observation made by the Honorable Supreme Court, read with their own chart. Kindly see their chart.
Where is their chart?
Well, kindly see, this is not the chart which must they have submitted. Because if your lordship sees the judgment at page 70,
71, 75, page 74, 75.
74, 75. It says, my lord, 74, it says, no, 74, no, 71, it says, final calculation. Then 74, 75 says, according to the final calculation made up to, kindly note, 1/5/1991. And kindly see their chart.
So we are asking you, where
Well,
is this? Where is this calculation which they had submitted in the contempt proceedings?
That nobody has the copy.
You have not got it.
No, no.
Then
That
how
is-
can we rely on?
That is, so my lord, kindly see, this is also not correct. Page 166 is also not correct.
No, we don't know whether it is correct.
I
or-
will show you, my lord. It is
Yes.
evident from the record. 1/5/1991, it does not mention anything about 1/5/1991. Kindly see bottom, my lord, 166 bottom. It says 1/6/91 and 1/5/1992. So this cannot be the final calculation which must have been submitted. So they have also,
No, but see, whatever you want, you have to establish with reference to your service and the rules.
yes.
Just because some document was filed and now it
No,
is
no, no,
untraceable.
That is a totally different aspect, my lord. I agree, my lord. That is a different aspect. What I am saying is,
Yes,
what I am saying is, as per
because
rules,
we are not in a position to ascertain today whether this was filed by them or not. Neither you have that chart nor they have the chart.
it is apparent, my lord, this is not the chart.
And the order which you are relying
Both
upon.
charts are, admittedly, both charts are not before your lordship.
So therefore, how do we know?
By the observations of the
That
Honorable
order has been set aside by the apex court.
maybe, but
that order
even,
has
even
been set
in a
aside.
degree of finding of fight, even if it is set aside, my
Anyway.
lord.
Anyway, it's not a finding of fact. It is a claim. These are rival claims. They file one chart.
No,
You
it
are still not accepting it. You say, I want more. The contempt court says, all right, that means you have not complied. You have to comply, and these are the consequences. The Supreme Court says this contempt proceeding is quashed, determination to be done afresh.
Right.
So therefore, can we turn the clock back behind the Supreme Court order when it says that determination is to be done afresh?
But I am seeking something, that determination
You,
over, and I have
you
lost.
cannot put an admission in their mouth. Therefore, if you can show the document that, look, this is Annexure D which they had filed, then we can ask them why you are taking a different stand. Just because a figure has emerged in the court's order, we are not in a position, because ultimately it has merged in the Supreme Court order. And the Supreme Court says that you determine afresh. So now can we go behind this? Thereafter, one writ petition was filed. The division bench has again said, no, it has to be looked into because you did not exercise your option for ROPA. That has been accepted by the division bench. So can we turn the clock back now? So therefore, we are saying, what are you claiming? If you can substantiate that by with reference to your service and the rule.
No, my lord. My claim is not on the, I am admitting this, my lord. Let us not, my lord, understand that as per rule, I am not claiming that as per rule I must get. I am saying my claim was much higher. I have lost.
Everything has
that
been
should-
lost. You are relying on one figure which has appeared in.
I have said that you had admitted something which was lower than I have claimed. You at least pay me that, both on equitable basis and on the basis of estoppel, my lord.
What is your difficulty? If you have given the chart, what is your difficulty?
Can you square it up? But according to the calculation sheet, page 165,
Yes.
last column 18750. And his calculation sheet is 2070.
No, that is the petitioner's calculation chart.
What should be the correct figure? But only when the matter has to go to the, since he has retired, he is getting pension. If
Matter has to go to
AG Bengal. Because
that chart which you had filed, you must be having it.
it was filed in long back when in the office was, that's right.
Yes, it is long back, that we understand, but because to
2004.
get over the contempt, you have given a particular calculation which has been recorded by the court in its order. Now, because it culminated in contempt, the Supreme Court interfered. But how can you now shift from that stand? That is what we are asking.
No, whatever the stand taken before the Supreme Court or before the High Court, we cannot change that stand.
Therefore,
what should be his pay on the Arupa Rule 1980? Another Rule 55.
where is the final determination of his benefits, which he is getting right now?
That is not, that is not on record.
How much is the difference? Instead of 2070, you have been fixed on
Represent. Well, at the time in 2003, I was getting 3774. I should have got rupees 4338.
No, we are asking you your basic pay. What is the fixation of basic pay on the basis of which your pensionary dues have been determined? How much is it at variance with 2070?
Well, my basic pay was 8,675. Has been fixed. No, should have been. It has been fixed much lower because I have the full pension amount I have in my representation. My should kindly see. I have mentioned the full pay, full pension.
He is getting full pension because more than 20 years service is rendered.
Full pension pachina.
He is saying that in 92 his basic pay was wrongly fixed.
Yes.
So therefore we are asking what is the wrong fixation in 92? 8,000 is as a result of the subsequent revisions or increments that you may have got. What is the basic pay? What is the difference between what you have got and what you, according to you, was stated by them in their chart, calculation chart? Otherwise, it will become a,
Basic pay
even if it is allowed, it will remain ambiguous.
8675 what should have been getting 3775.
So you don't know that means.
No.
What was the basic pay fixed with effect from 1591? You don't know.
No. Because if fixation was done continuously, even after the order of the Supreme Court.
How can whatever it is, whatever is the basis of the calculation today, you are the recipient, you should know.
Well, I was, because this before the Honorable High Court, in my second, after the Supreme Court, when I approached.
That means you must be getting 1850. whatever was their calculation. Instead of 1850, probably you are claiming 2070.
That answer was
much higher. It will be
Huh?
much higher because the difference is much more.
because
No, because that cascading effect will result into higher.
Yes, ma'am.
This as on 92, a difference of 2000, more than 200 is a big difference. According to them, you were entitled to what amount that have been stated at page 166. And according to you, it is what you have stated in 168. So probably it is 1850, which is the basis.
basic.
Well,
That after subsequent revisions and increment and all that may have increased to what you are getting today.
We have clarified page 159, paragraph Roman 4.
159.
155, paragraph Roman 4. Reply before the tribunal.
Roman 2.
Roman 4,
Yes.
159. Now regarding Plat 7A and 7B, the said application to state that the applicant complies with the court and court's order CS number, A contempt application applied, all the benefits of fixation of pay and promotion were duly given to the applicant. In this respect, though the depositing the appropriate contempt application, the Honorable High Court Calcutta in page 16 of the judgment, para 40, observed that we find that respondents have not yet mentioned a basic pay correctly and thereby failed to continue the consequent benefits of the petitioner. Made up to 1st May 99 has the basic pay out
Summons.
on as on 1st May 91, 2017. This may be compared with the basic pay of Hrishikesh Rai, who was since retired. In view of the observation, the Honorable High Court directed the respondent authorities and the petitioner to pay thereafter, keeping in view of the pay given to Hrishikesh Rai.
this is something else, man.
Order dated, so the said the appropriate order of 1st September 95.
So admittedly, they have not given me on this. scale.
Whatever has been fixed, he does not want this. But once they have said so, that's so you are not in a position to substantiate that whether that chart amount stated in the chart is due to you for any reasons having regard to your length of service or by virtue of
No, that repeatedly I am saying, my lord, because that claim is not on the basis of any particular rule or any particular scale of pay. Well, it is my purely submission. It was from beginning, my lord, in this proceeding. When I approach the even my representation, if your lordship sees, it is very specific. It is based on their claim that my pay ought to have been that particular amount on a particular date.
and the contempt proceeding is what case? What is the case number? The High Court contempt proceedings in which this amount was represented by them.
This was
2650 of 1990.
CR number.
CR number
2650
2650 of 1990.
W of 1990. This
CR means contempt rule,
Civil rule.
civil rule.
Civil rule.
It was at which page? Can you please?
but this starts from page 60. In your lordship,
Yes. Six five page 60.
Women Chen, Dilip Seth.
দেখছেন এটা কোনটা দেখছেন
এই যে এইটা।
ও ফার্স্ট হচ্ছে
হ্যাঁ।
মিত্র
হ্যাঁ,
কমেনশন
তারপরে
যে কমেনশন দিলীপ শেঠ দুজন জজ যোগমায়া সেনগুপ্ত কে জানি না, চেনে?
এখানে পাঁচে বসছে।
And this was for non-compliance of order passed in
Passed in the appeal, my lord.
FMAT.
This is FMM. The page 54. নাম্বারটা কই? No, এটাও হচ্ছে এই। নাম্বারটা দেখো তো কোথায়?
There is no case number.
Yes, মানে
Perhaps FMAT. No? One more. Yes, FMAT 1120 of 88.
FMAT
88 against the order of Justice Umesh Chandra Banerjee.
So this is the order of non-compliance of which was alleged in the contempt proceedings.
Yes.
Wherein that chart is supposedly filed.
Yes, madam.
From the list of dates. Get it. FMAT 1120.
কিন্তু তোটা কোনটা কারেক্ট কি করে হাইকোর্ট কি করে বলবে? এটা ঠিক যদি থাকে 1850 আর
ওটাও তো মিলছে না, ওটাও তো মিলছে না।
165
ওখানে কোনো ইয়ে ক্যালকুলেশন দেওয়া।
Then we are afraid if you cannot substantiate this claim, we are not in. Yes,
My claim is very clear, madam.
heard, learned advocate.
Based on
Item number 3.
I am appealing for respondent number 1, 2, and proceeding related to some instruction by from the
Some instruction.
pensionary benefit is getting. My lord had directed me to take instruction as to who is drawing that 2/3 pension. My lord, the respondent number substituted respondent number 1, that is the widow of the original respondent.
She is drawing.
Destroyed.
You are not able to get a hold of your daughter,
Oh my lord, I tried.
and she did not appear before the tribunal also.
No, no.
But in fact, during the lifetime of the incumbent, everything was paid to him. That was by way of compassionate allowance. He received everything. Now, the only question, family pension. The widow definitely received the family pension, nobody else. So, the question of substitution, I don't think that is, they are not at all. Had there been a case to fight out the proceedings, in that case, they could have come before your lordship. Is that right? Huh?
One son and one daughter.
Oh my lord, 2 daughters and 1 son.
2 daughters and 1 son. So
One- one daughter
one
is
son
not
and 1
appearing.
daughter is there with you.
Yes, yes.
Kindly see what we are giving to the widow.
So what is the order of the tribunal that you are aggrieved?
The tribunal passed an order because the revisional authority reduced the penalty from removal from service to 2/3 pension. That was the revisionary authority reduced the punishment. Unauthorized absence were there continuously for a period of a couple of years. He was found to be a habitual absentee, and therefore punishment was awarded. Appeal, disciplinary authority awarded the punishment of removal. Against that, appellate authority was approached. Appellate authority confirmed. Thereafter, revisionary authority was approached. Revisionary authority, taking a lenient view, reduced the penalty from removal from service to 2/3 pension. That is a compassionate allowance.
So that concluded during lifetime of the
Yes.
employee.
Yes. Thereafter, being aggrieved by the leniency of the revisionary authority, the incumbent moved the original application before the tribunal.
He wanted more.
He wanted more.
Obviously, yes.
Naturally. Thereafter, what happened? The tribunal, after hearing both sides, remitted the matter to the revisionary authority for consideration afresh, giving particularly the conduct of the proceedings, giving consideration with regard to the fault in the proceedings, department.
To examine whether there was any procedural error.
The incumbent was also directed to cooperate with the revisionary authority.
Yes.
Now, being agreed by that, we preferred this writ petition. During pendency of this writ petition.
Oh, during pendency, he is. You are not desirous of pursuing the matter.
Oh my lord.
She is getting it. The mother is
She
getting
is
it.
getting.
Substitution could not be effected.
Substitution was effected in respect of 2.
3.
Third was the daughter could not be.
Yes.
One daughter could not.
One daughter could not be traced out. They are not going to get anything because family pension is always given to the either widow or widower. So they are not the necessary party with regard to receiving the family pension.
Now you are saying after you have made efforts to substitute them.
Yes, because
This you could have said at the beginning. Now the court has already directed for issuing of service. Service has been effected on other 2 persons. One has not been effected. So can the process of substitution be aborted midway?
let them be substituted because otherwise, what could we do? Because the writ petition was pending. nobody was appearing for the respondent. The original incumbent died. So it was necessary for that purpose, not for other purposes.
No, the substitution was required. Otherwise, how could you have proceeded? But substitution of all legal heirs now, can one be excluded? We are asking you. Out of 4,
Yes,
3 have already been substituted.
Right.
3 have actually notice has been served on them.
right.
1 has not been served. Can he be or she be excluded?
That was subject to your lordship's kind consideration, Lord, whatever the position really stands now, Lord, that does not, Lord, affect the disposal of the petition, because virtually it has become infructuous. Virtually, it
If
has
you
become-
say it has become infructuous, then we have nothing to say.
Your lordship kindly see, Lord, because family pension is being received by the widow, whatever other death benefit, DCRG, death cum retirement benefits were payable, that has been paid to the original incumbent. So nothing remains.
So what is the tribunal's direction? Let us just see.
Page 9. No.
What is the direction?
Blood, page, blood, last annexure, blood starts from page 170. Ends at page 171.
In these proceedings?
No,
No. On the substitution application.
blood, your lordship has passed an order. In
What
the-
order? Only notices have been issued or it has been?
No, it's allowed or anything? Blood, the
Can number 2. Second.
Yes, ma'am.
Why? Why? It is for service of notice. Let it come. Anybody can be here. No, 2 p.m. we are fixing other matters. We require consideration. For notice, 2 p.m. Sorry. Yes.
Item number 4.
I appear in this matter for the petition. But petitioner before your lordship, Lord, before your lordship takes up the records, but I just give your lordship the crux of the matter. The petitioner before your lordship is seeking for family pension. Now, Lord, thing is this, Lord, the husband of the petitioner was a pharmacist in Purulia district, serving under the state of West Bengal health department. Now, Lord, the husband died in the year 2017.
While in service.
Yes, died in her. Now, thing is this, Lord, the question is the marriage between the petitioner and the husband. That is the question. Thing is this, earlier the husband of the petitioner married, the wife of the husband of the petitioner died in 2007. Thereafter, this petitioner,
wife of the, so the deceased employee's first wife died.
In 2007.
He predeceased him.
Yes, she predeceased. The husband of the petitioner, thereafter, started staying together with the petitioner. Now, they married, the husband of the petitioner married to the petitioner for the second time in 2009. In 2000,
that date is not fixed.
Now, thing is this, I shall come to what has fallen from your lordship on the other day, Lord.
Yes.
I shall come to that. The only question which, Lord, is required to be answered, that is marriage. Whether the marriage, second marriage was valid or invalid or void. That is the only question. If it is held to be valid, then, Lord, I am entitled to family pension and other benefits. I have got a son. Lord, Lord, he has got the 1/3 share by the tribunal regarding the death benefits. Now, Lord, I am not on that regarding death benefits. Lord, I do not have anything to submit before your lordship. Only thing, Lord, the family pension, as I told, Lord, the rule permits to get the family pension by the widow or by the widower. Now, Lord, whether I am widow or not, that is the test.
So, as per the rule, who is a widow?
Yes, Lord.
As per the rule, who is considered a widow?
Yes. Now, Lord, wife. So, Lord, if I am held, if my marriage,
a wife is a legitimate claimant to the family pension, the
yes,
first
yes.
claimant. Now, apart from that, there is a requirement of a nomination under the service rules.
Lord, family pension, there cannot be any nomination. Nomination can be made in respect of, Lord, the other benefits, death benefits. Nomination can be made, but the rule specifically provide for getting the family pension either by the widow or by the widower. So, Lord, I am, whether I am widow or not, that is the question.
Which rule are to be examined for this?
Lord, I shall come. Let me first. Now, Lord, the wife, the petitioner started living with the husband, with her husband since 2009. Now, Lord, the petitioner had also
where is my notebook?
No. এখানেই আছে ওইটা আমরা সোনালিতে যেটা দেখতেছি ওই সেম জিনিস অ্যাপ্লাই করবো ওটা বের কর এখান থেকে বের কর না ইন্টারনেট হচ্ছে প্রণালীতে যে প্রভিশনটা এটা দেখাবো আমরা, এটা দেখাবো এই মামলায় দেখাবো। হুম? আমি পাবো উইডোর উইডো দেখ। Now, the petitioner had also, the petitioner had also married for the second time. Because earlier the petitioner had another husband, and there was a divorce. There is a divorce between the petitioner and her earlier husband. Yes. Sure.
So what is the date of demise of the government servant? Just give us the details.
Yes. 2nd March 2017.
And what is the date since which you are living in?
3rd July 2009. 3rd July 2009.
2009.
Yes.
And you have solemnized marriage with him when?
Now, there are two dates. One is registration, that was taken into consideration by the concerned officer. That registration was held to be void because I had a divorce suit pending at that point of time.
So what is that date?
2012. Registration. No,
Mixed touch you can.
no, তা বলছি না।
2011.
কোনটা কি বলছো?
11/11/2011.
Date of registration doesn't. Mixed touch.
What is the date? 11th November?
Yes, but page 23, this is dated 30th March. 30th March 2012. তুমি কোত্থেকে with effect from 11th November 2011. With effect from
Page
23.
So obviously this has not been accepted by the tribunal.
That has not been accepted. Now, that has since
Because as on that date, the divorce suit was still pending.
yes,
Divorce suit is number?
suit number. I'm just giving the suit number. No, match suit number. Match suit decree. Decree টা করে। No, no. অনেক সিজি এটা কি?
Number 143 of 2012. Map suit number 143 of 2000.
কোথায় পেলে? Order impugned.
2012.
2012, right. Ujjwal Saha versus Srimati Snigdha Saha. Now, so the mat suit was instituted in the year 2012. And your lordship would be pleased to see the decree was granted.
7/4/16.
Yes, 7/4/16.
Yes.
7/4/16.
So prior to 7/4/16, there was no question of claiming to be a wife.
There is no question. I will come to that. The law is something subject to your lordship's kind consideration. I shall rely on certain judgments also. Now, this is correct. The authority did not accept the marriage registration certificate. So that could not be
One more date, if you can give us, what is the date of demise of the earlier wife?
Yes. Blood 4th October 2007.
7.
4th October 2007.
Yes.
Now, blood the date of death of the government blood
That is
employee-
there, 2/3/2017.
Yes. Now, blood the socially blood keeping in mind the rites and rituals, blood they socially married in the year blood 16, while on 20th June 2016. There is a marriage blood invitation card. Yes. Blood, your lordship would be pleased to see page 28. Blood, according to Hindu rites and customs, they socially married. Since blood the registration of marriage could not be accepted, since divorce was pending, mat suit was pending, therefore they socially married. And blood they started living together while one child was also born. These are all admitted positions. Now, blood the concerned officer blood only considered the marriage registration certificate and blood declined to accept my claim. Declined to accept my claim. That is the blood reason for filing the second round of litigation before the learned tribunal. The learned tribunal also blood did not grant any relief to the petitioner for the reason, although blood there is no second claimant for family pension, the tribunal did not grant the relief, blood considering the fact that marriage registration certificate was void because the divorce was not granted at that material point of time. Now, blood, the thing is this: blood, the tribunal ought to have looked into the social marriage between the parties. But that is also a valid marriage. That could not have been given any importance. Rather, that was not given any importance by either by the tribunal or by the concerned CMOH. Blood, giving thereby blood the denial of claim of the petitioner. Now, the thing is this: your lordship blood is well aware of the position of law blood regarding blood validity of marriage. Blood, if blood the Supreme Court has time and again blood reiterated, even in 2025, that if a man and woman cohabits for a long time, then there is a presumption of marriage. There is a presumption of marriage. Now, blood, it is admitted position blood the child has been given the share, 1/3 share of the deceased husband. So, blood, the law, blood presumption of marriage is also a valid point which ought to have been taken into consideration by the concerned CMOH as well as by the tribunal. That has not, that has been given a go by. Now, the thing is this: not the child has been, we are staying together since 2009. The husband died in 2017. So, if this is not considered to be prolonged living in relationship, even if it is not a marriage, and there is no second claimant, no other wife is claiming that I am the genuine wife, I should get the family pension. No, nobody is claiming. So, this is the background of the case. That I would rely on judgment.
Before we go to the judgment, let us see the rule.
Yes, rule. Rule take. 105. DCRB. West Bengal DCRB 105. And nomination 100-101. Nomination 100-101. And family pension, yes, This is family pension 101, 105 বলছিস কেন? Yes, 101, Lord, I'm sorry. এই ওই জায়গাটা দেখুন, we do
That also I have. Anyway, I can look through this. I've got this.
ডেথ সার্টিফিকেট আছে, পেজটা বলে দাও তো, ডেথ সার্টিফিকেট 33 না
Family has been defined in which provision?
Lord,
The definition of family?
just a minute, Lord.
It is 7E. 7E.
7E, right. 7E. GCRB, বের করো।
So wife in the case of a male officer and
Yes.
husband in the case of a female officer.
Target 7E, family definition আছে 7E। কি করে হচ্ছে? Hmm. 7E. Hmm. 7 equal.
Marriage is not
Hmm.
the marriage that they are claiming.
এই যে family.
Info the chapter. Before the marriage.
Family. Which one for her? Is it equal?
It has to be while alive.
Equal.
For this. For this. Yes,
Now, Lord, your lordship has seen the other provisions in the rule.
101.
Yes, 101. Application of 3 rules. Lord, family pension 102. That is
102 also.
102. Rate of family pension 103.
No, actually it is at the moment 7E is important.
Right.
Rate is
7E
not important. Once that issue is resolved, then 102 and 103.
7 is family definition of family. Now, Lord, so Lord, if I come within the meaning of wife, then Lord, I get the relief. Now, Lord, the thing is this, Lord, whether there was a marriage tie between the parties, that is the only question to be answered. Now, Lord, in my respectful submission, Lord, even if the registration certificate goes, marriage registration certificate goes, the socially acceptable, Lord, according to Hindu rites and rituals, that should have been accepted. This is number one. Number two, even if that is not accepted, I shall rely on the judgments of the Supreme Court that there is a presumption of marriage. Since there is a prolonged cohabitation between the husband as well as the blood petitioner.
The judgment you are relying upon arises out of a civil suit.
This is reported in 2014.
Arising out of a suit.
No. I just tell you. Paragraph 4 and 7 are important. I just read out. We have gone through the judgment and order, impugned and perused the record of the case. We are of the view that such observations had been made in the facts of that case. In fact, what the learned judge wanted to say is that if a man and woman are living together for a long time as husband and wife, though never married, there would be a presumption of marriage and their children could not be called to be illegitimate. Such a view stands fully fortified by a very large number of judgments. Now, in the instant case, the High Court made the aforesaid observations in the facts of the case as the alleged marriage took place in 1994 and two children were born in 1996 and 1999 respectively. Therefore, the observation made by the High Court in the said judgment are restricted to the facts of that case and do not lay down the law of universal application. Now, the thing is this,
You have still not answered our query.
Whether it is a suit or
it arises out of a civil suit or it arises out of a writ petition.
Just let me check. No.
You are not giving us copy of the.
This is I'm just furnishing. This is from judgment. This is arising out of some criminal revisional case from High Court.
So probably 125 or something.
This is arising out of.
So therefore, arising out of a proceeding which is based on evidence.
Right. Now, this is also rebuttable. Supreme Court in another case, this is rebuttable.
All presumptions are rebuttable.
Yes. Now, thing is this, this can be rebuttable, but general principle which has been laid down in other cases also, Your Lordship, kindly, I am handing up the judge.
How a writ court can declare a marriage to be valid? Or how the tribunal can declare a marriage to be valid? That is the issue before us.
The question of declaration does not come. The question of presumption will
So
come.
What is the order impugned before the tribunal?
Tribunal before the
The
tribunal.
order impugned before the tribunal.
Yes. I am just showing. The reasoned order passed by this human.
Where is that?
But 35, page 35. পঁচিশটাও বের কর 2025টাও বের কর এটা 3.7 0.5 থেকে ঠিক আছে লিখছি। এটা কোথেকে অ্যারাইজ করেছে সুট না কি থেকে অ্যারাইজ করেছে এটা দেখ।
So one son was born out of this wedlock
Yes,
and one son and daughter was early.
earlier.
Yes.
So and but this is the impugned order by the tribunal, but upholding the order passed by the CMO is that it is in the order. Now, Lord,
Tribunal's order is 26/8/19.
26/8/19. ওকে ভালো দিতে পারি, হ্যাঁ ওটা দেখে নিচ্ছেন দেখো জেরক্স করে দিয়ে দিত।
And what is the date of birth of the son?
Date,
Prior to the social marriage.
But page 24 is the birth certificate of the child. Page 24. Second April 2014. We started paying together since 2009. His registration was given.
This side.
Sorry. Yes. No, all right. So this is blood 2014. The
So prior to the social marriage,
prior to the social.
during the living in relationship.
This is number one, and blood, he has been accepted by the blood CMOH as a co-sharer of the death benefits amongst two others. Start করবে কিন্তু খুলে নি খুব ভালো ঠিক আছে প্রিন্ট আউট করে পাঠিয়ে issued by the three sir.
So what is the, since the three children have already been recognized, they are not getting the family pension.
No, nobody is getting the family pension. They have the children from the earlier marriage as well as from the later marriage.
Nobody is getting.
No, nobody is getting, and nobody is claimant, seven except me. Only claimant, myself, who is claiming for family pension. The family pension cannot be divided between the children and the mother.
The children cannot get the benefit of family pension.
In absence of mother, they would get. But that is in absence.
They can get.
They can get in absence of.
So if they say, if they are of the view that the petitioner is not a wife within the meaning of 7E,
Yes.
then they are obliged to give the payment to the three children.
But that has not been given. Page 35, if your lordship sees.
Maybe not given.
Yes.
And if it is given to them, then what remains? Then what will remain?
But let me see page 35 once again. Will kindly see what has been given to the children. What has been given?
No, what is, that is for you to say. It says the claim will be divided into 3 equal shares.
Opinion in the government period regarding legal heir of deceased Joy Das. I am of opinion that the first party members are legal heirs of the deceased Joy Das, and the second party member can.
Mr. Rai, come to the last. It says all claims will be divided in 3 equal shares. So then what remains?
Family pension,
all claims, it says all claims. It is not excluding anything. Therefore, we are asking you, then what is your grievance then? If all the claims are to be paid, the other two who are born from the earlier wedlock, they cannot be deprived.
Certainly.
So if it is being paid to all three, whether in their name or your name, what difference it makes? Because that is the order of the CMOH. All claims, or he would have said claims other than family pension, but he has not said. He said all claims in 3 shares.
But your family pension usually is given to the.
Perhaps it is not being paid because you are persistent that it should be issued in your name. Perhaps we don't know whether it is being paid or not, because it says all claims will be divided in 3 equal shares. So after this order, where is the assertion that in spite of this order, it is not being paid?
No, but another thing is also there, Lord. If your lordship sees, because Lord, the
So apart from family pension, even compassionate appointment has been finalized. Then what remains?
Yes. But that's why I was saying, Lord. Here, your lordship would be pleased to see, Lord, understand, agree with the legal year certificate issued by the district magistrate of Purulia, revenue so and so section, and come to the opinion that all the claims will be divided in 3 equal shares to Jiddas, Dolidas, and Otonudas, and the service on compassionate ground may be offered to Jiddas or Dolidas. Why, Lord? This is also arbitrary. Why? He came to a conclusion that the children from the earlier marriage, they would be given the compassionate appointment, either or. why Atanu is deprived? Why Atanu is deprived?
What is the age of Atanu?
14. 14.
How he can get? And this benefit is not given for the benefit of the recipient. The concept is to pay it for benefit of the family. He will have to give an undertaking that he will maintain all these 3 persons. Every year, that undertaking has to be renewed. If he fails, he will be deprived. So what is your apprehension? That we are asking.
No, you forget that. So, Lord, in that case, Lord, if your Lordship holds that
So what are we to hold? It is all there in the order of the CMOH.
family pension is being disbursed.
We don't know.
Let
No, where have you said in the writ that in spite of this order, nothing has been paid? Show us from the writ petition or in your OA.
family pension once. কোথাও কিছু আছে কিনা কোথায় বলা আছে কোথায় বলা
Let's see what is the relief paid in the OA. So she wants her share also. That is all. It is nobody's case that those 3 persons are not receiving. She says, I want my share also.
No, but nothing is being paid to anyone.
No, that we are not finding anywhere. And you cannot say so unless it is stated in the OA.
I have just taken instruction to my junior whether he has got anything. Lord,
We will go by averments in the OA.
Lord, that would be better apprised by my learned friend appearing for the state.
We are not going to ask him unless you make out a case in the OA. We will not enter that arena. Because before the tribunal, you have only claimed that a share should be given to me. It is not your allegation. In fact, you are challenging this order. You want that this order should be set aside and your share should also be declared. You are not claiming implementation of this order.
Right, I am not claiming.
So therefore, that is not an issue before us.
I am claiming for getting blood getting blood.
So you have impleaded the other 2 persons. The son and daughter of the first wife, have you impleaded them? Because the moment one share is made for you, their share will diminish. Instead of 2/3, they will get 1/4. How it can be granted in their absence?
But possibly in the first original application, they were made parties, but in pursuance of the order, because in pursuance of the order.
Is that relevant today?
Of course, that is very much relevant.
Not at all, sir.
For the reason
Now you are challenging the order whereby 2/3 has been given to 2 persons. You want that to be decreased and you will not implead them as a party and you will get an order.
So that the reflection in the order of the CMOH, in the reasoned order, the names of the parties are there.
Yes.
They have been given the share. That order is being challenged.
Yes.
That order is being
So
challenged.
those beneficiaries are not to be made a party. Whose share is going to be diminished, they are not required to be
No,
parties.
that is.
Other? So why you have not, how you can file the writ petition without impleading all the parties before the tribunal? And you are arguing the matter on merits.
এই way থেকে then blood I must say blood the conducting advocate blood who drafted the writ petition blood he ought to have added these parties.
Most necessary.
Most necessary. That could not be. That,
No order can be passed in their absence to their detriment.
but certainly, I certainly I accept. But let me have the liberty to add them in the petition. I shall serve and come back after 1 week. Lord.
In the OA, they have been impleted. OA also you have not annexed. How can we see?
430.
The
Just no, not only applicant and respondent.
Maybe perhaps on the first day it may have been disposed of, we don't know. You should also file a supplementary, place on record the OA. Why you have not filed the OA?
Already.
In the meantime, the writ petitioner should also
Item number 5.
Item 5, my lord, I beg to appear for the petitioner, my lord. Yes. हाँ हाँ बोलो ना. My lord, in this matter, Mr. Atarup Banerjee is appearing for the Union of India, my lord, and he requested me over telephone, my lord, since his mother, my lord, fell down, so he rushed to the nursing home. So, no, my lord, day after tomorrow, my lord, kindly.
Mr.
Item number 6. Good being.
Your Lordship, for the purpose of recapitulation, the points involved here in that 1997 selection process commenced. We appeared, selection process cancelled. Ultimately, we lost, and then High Court ordered interference. Only the written test was conducted. The entire panel was cancelled, and no one was appointed from the selection process. And 29 January 2014, the order by virtue of this, my lord, we were appointed. Now, my lord, after the appointment was given, my lord, we made a representation seeking, my lord, the notional benefits so far as the fixed promotion is concerned. My learned senior friend, my lord, has relied on the document. The Honorable Tribunal, my lord, rejected our claim because the order dated 29 January 2014, my lord, it says, my lord, the appointment shall be guided by the 97 rules. The National Pension Scheme, my lord, was not made applicable. There was a memo issued by, my lord, the authority giving protection to the petitioners before your lordship that we will be guided by the pension scheme, my lord, not the NPS. My lord, when the NPS was introduced, my lord, it is my instruction that we were asked to, my lord, deposit a certain amount of money, my lord. That was lying with them, my lord. That was, my lord, under the scheme. The government is entitled to, my lord, take such money from us, my lord, or deduct the money, and that will be lying in that account. Now, during the
So deductions under the NPS are being made.
So, my lord, today, when the matter was taken up for consideration during the pendency of this writ petition, they said, my lord, that we are not entitled to, my lord, because there was a cut-off date within which, my lord, we should have applied. And that is why, my lord, the reason for withholding, my lord, the benefit that has been conferred upon us, my lord, according to them, my lord, if I have correctly understood the minds of the respondent, it was a mistake. We are not entitled because we did not apply. Fact remains, my lord, the affidavit which was supplied to us. I do not know, my lord, in the original affidavit which was submitted. My instruction is this, that one page is missing. One page is missing from the government affidavit, which contains, my lord, a particular sentence saying that those who were appointed in pursuance of the selection process conducted on or before 2003, they are automatically entitled, my lord, that is my interpretation, not the language, my lord, to the original
Old pension scheme.
Old pension scheme upon exercising option. Now, my lord, this option was exercised, but my lord, with a
You exercise this option.
Yes, exercise the option because it made applicable because you were appointed in pursuance of the recruitment process started, my lord, on or
No,
before
that you have said, that
Yes.
High Court said under 97 rules, so
Is that
therefore
right?
97 rules.
Now, my lord, the judgment which my learned senior friends relied on, my lord, that I was not born in the cadre, my lord, when the appointment, that is 2014. So I did not ask for, my lord, the arrear salary. I said the notional fixation. I said, my lord, I was not sitting on the fence. I pursued my right since 1999. Now, my lord, whether I can make this submission before the highest court of the state, my lord, in this proceeding, that the cause of action that arose, my lord, in 1999, I continued with that cause of action. I could not anticipate, there was no occasion for me to anticipate, my lord, to ask for, my lord, the notional benefit of the pension, because it is imbibed in the order inherently that when the court grants an appointment, presumption is, my lord, in no uncertain terms, that there was no delay, there was no negligence on the part of the writ petitioner, and it was based on justice, equity, and good conscience, my lord, in addition to not in derogation of, my lord, Article 14. I was discriminated, Article 14. I was not given appointment. It was because of the High Court's endeavor. High Court's exercise, my lord, we were given appointment. And pension scheme in relation to these appointments made in pursuance of 1997 recruitment rules, more particularly by virtue of an order dated 29 January 2014, my lord, all persons were given, my lord, the old pension scheme benefit. Why I have been excluded from the zone of consideration, more particularly out of 8, only 2 persons that has been withheld during the pendency, this is according to my humble understanding of law, an executive inroads into a judicial order or judicial process.
So how many persons were party before the writ court?
Here, not there.
Before the writ court, which passed the order in 2015, how many writ petitioners were there?
60 my lord, so far as we are concerned. But we, my lord,
So 58 have been granted old pension scheme.
they ultimately only 28 joined.
So out of 28, 26 have been granted.
That is my instruction. What he will say?
No, where have you said that?
No, I did not say. I say, my lord, that the only out here, my lord, out of 8,
Don't make out such cases which are not there in black and white.
Not in pleading, I said there is one.
Then we'll
I
not
did
accept that.
I never will travel beyond the records. That is why I say that is my instruction, not on pleadings. So, but today, Millard, they said you were not born in the category, you cannot claim anything.
So the issue is not whether only 2 have been left out or 26. The issue based on pleading is what does 1997 rule mean in the order? Does it mean that you are entitled to everything or it doesn't?
But my respectful submission that 29
You are deriving sustenance from the order passed in 2014.
First of all, your lordship has to be convinced on two principles whether the Reed Court can grant Millard compensatory and or restitutory relief. If it is restitutory relief, then Millard, I cannot claim
That is not an issue in dispute. These issues stand settled. The point is, it is to be granted when?
from the
In
date
the
of presentation.
2014 order or by this court today?
Yes, because
If it is not in the 2014 order, is it to be done today? If it is in the 2014 order,
14 order is very specific page.
then is it required to be done today?
No, today Millard, yes. Why it is required to be done? Because the presentation of claim, because cancellation was a subject matter of
So
challenge.
let us see whether 2014 order gives you the right to claim the
No,
back
but today,
benefits.
Millard, there was no occasion for the High Court. What I say it is a consequential. Number one. Number two,
It
when
is the
consequential inbuilt. It's a consequential relief. I said, Millard.
So therefore,
If
you are claiming in terms of the order passed in 2014, then no further orders are required to be passed.
Millard,
We will only have to say that that order means that you are entitled to everything.
if your lordship accepts a submission.
No, that
Yeah.
what is your case?
This is my case.
What is
because-
what we accept will come later.
Now, Millard, if the
Or
court-
is it your case that this has not been said there, you have to say now?
No, the tribunal disbelieve us because tribunal said it should have been explicit in the order. I cannot assume, I cannot add something in the order.
So therefore, what is the infirmity in this finding? That has to be seen.
Number one. Number two, Millard, whether I can say, Millard, that the presentation of claim is a point of reference while Millard adjudicating the lease between the parties. Millard, 1999, order to Rule 2 of the Code of Civil Procedure, all claims should have been there. Now, Millard, 1999, I was not certain about, Millard, the position. I was only saying the cancellation is bad. The court made an appointment. The court made an appointment on the basis that Millard,
Therefore, we are saying whatever you cannot blow hot and cold. You have to take a stand that the order passed in 2014 includes this benefit.
right.
Or you have to take a stand that the order passed in 2014, we had no occasion, therefore we have filed this. What is your case?
My case is a notional fixation of the pension. Pension scheme was made
No,
applicable.
why in these proceedings based on, if it is not in the earlier order?
Millard, yes, in terms of the recruitment rules, whether the recruitment rules.
So you want us to interpret the earlier order of the High Court?
No, I said, Millard, that notional fixation is automatic, or I can claim notional fixation. I am not paying arrear salary. Your lordship, that is why directed my client to file an affidavit, supplementary affidavit. What is our stand in this proceeding? We do it so. Now, Millard, the central government has taken a stand, which is not the case before your lordship. I never asked for the arrear salary. I said, Millard, the determination of seniority, Millard, that is from the date of joining.
So you want seniority also from that?
I said, Millard, the notional fixation only, and Millard, if the fixation and the pension scheme that was given to us, that cannot be withdrawn.
So you want that the period should be counted as service without any benefits. This is the crux of your submission.
And Millard, that is why whether it entitles me.
We'll see.
Millard, today
I appear on behalf of the appellant.
Original side, daily list, item number 1.
Just I had taken my lord, key points. I don't think with great respect, my lord, my learned friend, my lord, has at all touched on, my lord, the other 2 points.
He has focused on the issue of maintainability.
On the question, my lord, on the question of, my lord, that we had urged a point with regard to the resolution plan, and that is not
That
correct.
has attained finality up to the apex court,
No,
and
my lord, that's
therefore,
only one of the points. If I fail in that, I fail in that. But the other 2 points, my lord, which have to be considered. In fact, my lord, that's why I laid stress. My lord, we were under the impression that, my lord, the resolution plan, when, my lord, there's a resolution plan, that will, my lord, all past liabilities would be gone. That is in terms of, my lord, Ghansham Mishra and all the judgments. And, my lord, there was a specific clause, clause 15.5. It appears, my lord, that it was not approved in that sense, though, my lord, the NCLT and, my lord, the Honorable Supreme Court said nothing about it. But since, my lord, there were appeals, my lord, from the NCLT order, my lord, and since there was no comment, my lord, we stressed that point also. My lord, recall, my lord, there was a specific clause which says, my lord, no further fees. And that was the issue on which we, my lord, fought before the NCLT, saying that relieve me from the resolution plan because I will be imposed with liability. NCLT said nothing doing, and then, my lord, I also showed their stand where they said no, there's really, you can't complain about that because nothing has been imposed as yet. It's premature. So that's one of the points. Second point, my lord, which is more important, and, my lord, I've relied on judgments for that, saying, my lord, that when there is a change in the shareholding of the company,
yes,
then also it doesn't amount to a transfer of the lease because the corporate identity is the same and the lease continues in name of the corporate identity. And I'm all relied on, my lord, about four judgments, my lord, on that. So to recall, my lord, that Gopi Ballav, Greenheart, Lord Gopi Vallabh, my lord, which is a division bench. Then, my lord, Din Chemicals, single bench, my lord, of, my lord, the Chief Justice, my lord, as his lordship then was, my lord, then Greenheart.
Greenheart is by an honorable single judge.
Single judge, my lord. Greenheart by a single judge, my lord, Din Chemicals, and, my lord, Gopi Vallabh, my lord, is a division bench.
Yes, you have placed this.
Yes. So, my lord, that point, with great respect, my lord, has not been answered at all. Because if I miss out on one point, if there are 3 submissions I make, I may be wrong in one. My lords may accept it, may not accept it. But, my lord, the other points are also, my lord, substantial ones, my lord, which have to be dealt with. That's second. And, my lord, thirdly also,
Yes.
and, my lord, the third issue, my lord, was that the land allotment, my lord, policy which they came or they relied upon is a subsequent policy, which is, my lord, it's post the entering into of, my lord, the lease agreement. So I raised the issue, my lord, whether by a unilateral land policy which doesn't have statutory force, it's really, my lord, a direction, my lord, to the respondent authority, whether, my lord, bilateral contractual terms can be changed or not. Because that is what they, my lord, rely upon.
to charge transfer fees. That was, my lord, the third point.
Yes.
And my lord, just in the impugned order, and my lord, I understand, my lord. Sorry, my lord, there was an argument made saying, my lord, there's an issue estoppel. My lord, I really, with great respect, I've not understood, my lord, how issue estoppel comes in. Because if I raise 3 arguments and, my lord, 1 argument is not accepted, then doesn't mean, my lord, the other 2 arguments go away. And in the judgment, my lord, in the impugned judgment, my lord, kindly comes to, my lord, the memorandum of appeal. My lord will find, my lord, and that was my grievance. Saying, my lord, the learned judge, my lord, has noted the other arguments and particularly, my lord, kindly look at paragraph 4, page 4. My lord, page 4, my lord, paragraph 4, my lord, in the memorandum of appeal, the impugned of the internal page, my lord, of the impugned order. Paragraph 4, my lord, will find, my lord, both arguments are noted. My lord will see 10th line, the land allotment policy introduced by an order date 26 is prospective in nature, neither applicable nor existing lease, not to proceeding under insolvency. Then, my lord, D, there is no provision for transfer. Then, my lord, after 5 or 6, then mere transfer of shareholding, holding of the lessee company under the code cannot be termed as a transfer of lease. Any event the impugned demand such are beyond the scope of the approved resolution cannot be demanded. My lord, these are the 2 points. Then, my lord, see paragraph 5. The judgments are also noted. At paragraph 5.
Yes.
Then, my lord, with great respect again, my lord, to the learned, my lord, the single judge, my lord, surprisingly, in paragraph 6, I, my lord, told in the second line, I misinterpreted the orders. That my submission, it may be wrong. The court may not accept my orders, the submission which I make on a question of interpretation. But that can be a ground, my lord, for dismissing the writ petition because I made an argument.
Paragraph 6.
Yes, my lord, paragraph 6.
You are referring to?
My lord, paragraph 6, my lord, kindly see page, internal page 5, my lord, to the petitioners. My lord, has that, my lord? It's about, my lord, fifth line.
Yes.
To the petitioners, my lord, has that? Though the petitioners have sought to make out a case that the demand raised by the WBDC is grossly against the orders passed by the learned NCLT, learned and inclined Honorable Supreme Court, fact remains that the petitioners failed to obtain orders in their favor from all the aforesaid judicial forum and have misinterpreted the orders passed by them with a view to obtaining an order in favor in the writ petition. Learned Counsel has taken this court to clause 15.3 of the resolution plan, demonstrated approval, exchange, waiver ordination not granted. It will not in any way jeopardize the resolution. Shall remain responsible for such implementation. Clause 15 answer. Then, my lord, 7, clause 15.5. And then, my lord, paragraph 8. This is, my lord, the court's observation. And our interpretation, my lord, we might have put an interpretation which is totally wrong. You reject it, but that can't be, my lord, a question, my lord, of rejecting the other 2 arguments or dismissing my writ petition. This is, my lord, why, my lord, we are aggrieved. Because kindly see, my lord, then, my lord, sorry, my lord. Paragraph 11. And this is the only ground. It does not go, my lord, into the, with great respect, my lord, on the question of issue of maintainability. If I place an interpretation of the order which is wrong,
Yes.
because according to us, my lord, the NCLT enclared on the Honorable Supreme Court by reason of approval of the resolution plan and by reason of Ghanshyam Mishra, I can't have, my lord, any further liability. I may be wrong. I also make two other points saying that you can't have a retrospective change with regard to the bilateral terms of contract which has been agreed between us by reason of your policy. Thirdly, I also argue that, look, even if you dismiss all my contention, even the courts have held, now the law is that if there's a change in shareholding, it doesn't amount to a transfer of the lease.
Yes.
And those 2 points, my lord, are not considered, and my writ petition is only dismissed on the question of that, my lord, the court has refused to accept, my lord, one argument, which is, my lord, an interpretation of the orders.
Yes.
And those questions have not been decided at all, my lord. We'll find, my lord. And with great respect to my learned friend, my lord, there is no question, my lord. The judgments which were relied upon are on the question of suppression. Suppression is different. Giving an interpretation of the another court's order which this court does not accept is not, my lord, suppression by which, my lord, goes to the maintainability or, my lord, goes to, my lord, dismissal of the writ petition.
Yes.
But I think, my lord, if no further, my lord, clarification, my lord, I think, my lord, I'll be only, because I made my submission, my lord, I don't want to, my lord, unnecessarily
So
repeat.
broadly, you are on 3 grounds.
Yes, I'm on 3 grounds. On the question, my lord, that if I give an interpretation of, my lord, a previous court's order that doesn't, my lord, amount to, my lord, either maintainability or misinterpretation, even it's an interpretation, it is wrong. Court doesn't accept it. Doesn't mean, my lord, my writ petition will be dismissed. Secondly, my lord, I say that change of shareholding does not amount to, my lord, a change of transfer of the lease, which, my lord, law supports me. And the court has not dealt with that argument. Thirdly, I say that you can't have a bilateral contract changed by having a subsequent direction given, my lord, or direct policy. Otherwise, my lord, no contract, my lord, will then, my lord, be sustained.
So the policy is subsequent, it will.
Yes, yes. Policy, my lord, is subsequent. That's, my lord, the argument is also noted, my lord, in paragraphs, my lord, which I showed, my lord, paragraph 4, my lord, of, my lord, the learned single judges, which have not been considered. My lord, those are our submissions, my lord. I'm very grateful, my lord, has given us, my lord, a very, very patient hearing, my lord. I'm so happy, grateful. My lord, I don't think, my lord, written notes, I don't think, my lord, or, my lord, if my lord wants, my lord,
You can give us.
my lord, it's entirely, my lord, up to court, my lord. If my lord wants,
So
my lord,
if it satisfies you, you can give us.
so, my lord, if my lordship, if my lords want, my lord, then we can give. Otherwise, my lord, I don't.
Give it by Monday. Monday.
Yes. I'm extremely grateful, my lord.
Item number 7 and 8.
This is 8. What are these?
This is land loser.
We are not taking up those matters. Will come after the holidays. They have informed us 4-5 orders have been challenged. Let it
They have not.
let it attain finality, sir.
Land loser.
You are not giving any number. Why are you not giving us a number?
What is the number of SLP? They have not. Not I make a
Until
calculation.
now, only on your submission we are. Can you give us? Only one. You said 3 or 4 have been filed. Huh?
Similarly situated matters are pending accepted at the executive tribunal. Here they have stated that they have not filed any case. 969 of 20.
249.
24969 of 24. 249. Just please give it on a piece of paper so there is no mistake.
There.
You got the number? What is the number? 503.
50300.
Was also filed. That is the number of the rule.
So we should give that also. Give that both the numbers. Because relying on that judgment, the later judgments have been. So we have to give all. So give it, please.
It was also not a contempt file, but
Both the numbers will mention in the order. And you please.
ওটা আমারই কেস দিতে পারলো 5030025
10th November after the holiday.
Number 9.
9 I actually. my lord, the brought a commission. Yes.
Your claim pending before the tribunal.
The tribunal has not finally disposed of the matter.
What is your claim
claim
pending
I'm
before the tribunal?
I'm coming.
When we are saying pending, it means it is not disposed of.
It is not disposed.
So we are asking you, what is your claim pending before?
Claim before the tribunal was, my lord, the promotional, in spite of having all completion of all formalities, and my lord, the promotional benefit was denied. And whose is the lack of qualifications, even they have not passed the type of test and computerized test, they have been given promotion. We have challenged the promotional of the private respondents from group D to group C. We are the eligible candidates from group D to C in the Inland and Waterways Department. This was the challenge, my lord. I came before this court due to prolonged pending litigations. The court passed an order directing the tribunal to dispose it of. Tribunal, due to non-availability of the division bench, tribunal adjourned the matter. That's why I came before this court. Now, my lord, if the entire matter is heard out, because now the tribunal is not functioning up.
Sorry, we will not.
From yesterday, if your lordship, my lord, entire matter, that will be the, otherwise only.
We are not going to entertain this. You have to go before the tribunal.
Only the problem, from yesterday, the tribunal is not, there is one of the member retired from yesterday. The tribunal will not be functioning.
The sole member has retired.
Yesterday. So there will be no tribunal from today itself.
Yes, retired. How he can retire? He should retire at the end of the month or at the beginning of the month. How he can?
I got the information yesterday. Retired.
8th.
Yesterday. That was the last.
Before the state tribunal.
Today's 9.
Let's see. We don't know. But immediately, just because he is retired every day. Let us see. They will appoint someone. Promotion is nothing. You can get all the dues whenever it is decided.
No, they have passed an order during the pendency of the writ petition.
We are not going in the merits. We are only looking at a claim for promotion, challenging promotion granted to others, seeking a promotion by the tribunal. First of all, how a tribunal can direct to grant a promotion, that is an issue. But we are not going to go into that. Come to your prayer, sir. Come to your prayer. Yes. At directing the respondents to issue promotion orders. We have yet to come across such a direction.
May I draw your lordship's one order? The state authorities submitted before the.
We are not going in the merits.
Allow me 1 minute. 1 minute, time, your lordship. The state authorities submitted before the tribunal the entire matter we are considering, promotion, non-promotions, private respondent, including ourselves, and it is pending before the finance department. Kindly adjourn the matter so that finance department can take final decisions. If the state authorities, my lord, apprise the court, this is the decision which has been taken. I believe, my lord, no argument is required. If your lordship kindly have a look to this, that order on. So entire matter can be disposed of.
no referring the matter tribunal, nobody should be prejudiced. Your lordships kindly have a look to this order passed by the submission made by the state authorities. If your lordships smile kindly, that will be the interim order.
You are appearing.
Interim order. Interim order. আগে কি নাম ছিল? সপ্তক সান্যাল কে আছে? সপ্তক সান্যাল।
ক্যান্সেলেশন চেয়েছি তো আমাদের
Yes, you are trying to show us something.
Yes, page 55 of the application for interim order, if your lordships kindly.
Yes.
Kindly text of the. Your lordships kindly. The order dated 13/1.
This is prior to filing of this OA.
13/1/2025.
Page.
Page 55 of the application. Can one.
Can application.
সপ্তক সান্যাল সপ্তক SAP সপ্তক সান্যাল
So therefore, there is nothing either, even before the tribunal, there is nothing pending.
They have issued an order in violation of the promotion rule. Just let pay also can happen. The relaxation of the conditions.
We are not going to go into the merits.
What I will suggest, if this memo, if the finance department cannot give benefit to all, then
We don't know. We don't.
let it come. In the absence of the other, otherwise, you will also delegate the matter that the other is not being answered. It is the same problem.
We understand, but then not every issue can be taken up by the High Court. Even if tribunal is not function, every issue will not be taken up by the High Court. Matters of grave urgency, we may. No promotion, what is this? Nothing. No urgency whatsoever.
Because of the fact that they have declared maximum.
Maybe so. All the more reason for no reason for no urgency. You are not required to work under your junior also. So it is only a question of consequential dues. You can get it whenever you want. Not required, not required. We are not interested in hearing the other side. We are not going to interest. We are not concerned. Which order?
Came before this court.
All right. So that is an order prior to this order. That is all. That is an order in the series in the order sheet before us. So it is subject to final order being passed by us. Yes. Yes. Whatever it is, we cannot take up. We have.
157. Page 1.
This is order passed in these proceedings.
Yes. The landed advocate appealing for the petitioner submit the state was taking numerous adjournment of the plea, filing the reply, stating unless the delaying the disposal of the original application. He seeks a direction for disposal of the original application. Submits.
This is not in these proceedings. This is in an earlier proceeding.
This proceeding is WPSC 160 in connection with this matter.
This is already disposed of and we are still hearing it.
Disposed of directing the tribunal to hear of the matter.
So therefore, how it is still pending?
Because the tribunal adjourned the matter on want of discipline. That is the case.
That is he.
I could not find the case of
When we say this is not in this proceeding, you say it is in this proceeding. It is not in this proceeding. This is in WPST 16. We are not hearing WPST 16. It is in the same matter, you may say, not in the same proceeding. So, there may be many cases filed. It does not become the same proceeding. This proceeding is arising out of WPST 187. 187. This is WPST 187. This is not WPST 16.
No, I came before this court.
That we have understood, that we already saw before you showed us, we have already seen. What can be done?
And I came before this court, against the order dated 21st December 2022.
Not in a promotion matter, sorry. There is no urgency.
What can
Hard learned advocate. Some of the petitioners have retired.
Motion দিয়েছে তারা রিটায়ার করে গেছে।
হ্যাঁ, petitioner is taking the petitioner.
Motion দিয়েছে payment is not clear.
আমাদের তো রিটায়ার করেছি।
আমাদের রিটায়ার করে গেছে। আমাদের রিটায়ার যারা প্রমোশন অলরেডি পেয়ে গেছে তারা রিটায়ার করে গেছে।
Can also.
Sir, I'm sorry. Retirement takes place who has been given promotion. That is not next promotion. So they retire. So petitioners have not retired. Retirement, they in favor of the promotion.
How can you make such submission, sir? Once you make some submission and then 5 minutes later you make another submission on facts.
Petitioner respondent, there is
This is the way.
there is a
This
mistake.
is the way.
But the petitioner.
First, you emphatically submitted that they have retired. Now again, you are revising your submission. These factual submissions you are
I'm sorry.
ascertaining in court.
There-
We are passing order. After that, you are telling us.
Sorry, but
This is
that
the way.
means the respondent.
As from a senior person like you, we should expect this. What they will learn from you.
That is the way that still the private.
This is not expected at all. Not at all.
But this is the.
This is
factual
not the way.
has not been made. Appointment has not been made. See the information which got to be given by that.
Then why do you? That's why we don't take any oral instructions. You keep taking instructions and making submissions. This is not the way in appearing in a court before the High Court division bench.
That should not happen.
When it comes from you, we expect some responsibility.
That's
This is not the way.
then that motion should be.
What deleted?
Petitioners have not.
We don't know. What you have said, we have recorded. Now we'll ask him where it is written, we'll strike it off. This is the way, sir.
Some of the.
Please try to understand what we are saying.
Some of the promotion. which-
Whatever it is, we are not on that. Before you make the submission, you should be sure. You are taking instructions in the course of argument, making submissions and then revising it.
The tribunal.
We don't expect this. We are not on what you are saying.
If the tribunal takes up ballot, this question may be raised by some of the.
All right, you delete that retired issue. Only where the petitioners have retired, you delete that.
Number 10.
I appear the petitioner, your lordship. I am led by learned ASD. He has prayed that the matter may be taken up after the vacation, your lordship. Due to some health issues, he is not able to come to the court to argue.
Has jointly prayed list after the holidays.
Number 11.
Milord, 11 to 14, Milord, and 16 and 17 are all land loser matters, Milord.
You appear in all these matters.
Yes, Milord. I appear with my
So who
learned
is
junior,
here?
Milord.
Who is here from your side?
Milord, my junior is for the other bench. Milord,
No, we would like someone to give it on a piece of paper, all the serial numbers.
serial number. Milord, I shall tell one of my learned juniors will hand over to your lordship's court officer.
Who
Just
is it? Where is he? No, because we have to pass the order. We can't wait any.
Milord, 11.
Who is for the petitioner?
Let me.
Online, how he can give us the details online? Somebody has to be here.
Milord, my learned junior will. I am ringing him up to go to your lordship's court officer and hand over the slip. Milord.
You, which matters? You tell us.
11, 12, 13, 14,
11 to 14 and 17.
16 and 17.
No, not 22. He is not appearing in 22.
No. Only up to 17, Milord. Barring 15,
Who is
only up to
appearing
17.
in 16? Who is appearing for the railway in 16? Because he is saying 16 also.
Yes, Milord, 16 is there.
In 16, you are not appearing. Who is appearing? in 16?
Milord, in all probability, because your lordship was adjourning the matters because of that Supreme Court, they have mentioned that is why, Milord, probably someone is not there on behalf of the respondents.
No, that doesn't justify absence. The matter is there. Somebody should be here.
Definitely, Milord.
So, pass the same order which we have passed in the earlier land user policy, that review number and the other case number. 10th November, we have fixed in the other matter.
Lordship.
11 to 14, 16 and 17.
My lord.
Nobody for railways. In 16, there is none for railways. Yes.
I'm grateful.
Yes.
Milord, I'll place it in the chat box, Milord, the numbers also, so that there is no difficulty in the chat box.
Please do that. Yes.
Lordship. I'm grateful.
Lordship, item number 15, Lordship. Item number 15, Lordship, the learned ASG is appearing, Lordship. He has not come, Lordship knows. So, the matter can be done on Monday, Lordship. There is an interim order which was till yesterday. So,
Lordship for the respondent. Give
respondent, Lordship, Mr. PC Das and Kinnar Ghosh. Somya Majumdar, Lordship, senior advocate Somya Majumdar is for the respondents.
So let it appear now the other side of the holidays.
Lordship, there is an interim order that was, Lordship, till 8th of September. I mentioned also before your Lordship yesterday, there was an
If the continue the entry order till
there was a resolution yesterday, Lordship.
continue the entry order till 10th.
Number 18.
Good. Land user মামলা ওগুলো সব এতে হয়ে গেছে 10th November. Lord, in this matter, Lord, I appear for the Petitioner Union of India. Your Lordship heard this matter on several occasions. The Lord, thing is this, Lord, my learned friend appearing for the respondent is Lord, not appearing for last 2-3 occasions. In the last, now Lord, thing is this, Lord, they have filed one contempt application and they are pressing for the Lord, implementation of the order. So, Lord, he is not appearing here. Lord, although he appeared for 2-3 occasions and he absented for 2-3 occasions.
Last day he was here. Last day he was here.
Now, Lord, on one day immediately before Lord, the summer vacation, Lord, I prayed for Lord the matter be fixed in his absence. I prayed before your Lordship that matter be fixed after vacation. Lord, taking advantage of that, your Lordship kindly see what he has done before the tribunal. Kindly see. He said before the tribunal in contempt proceedings that we are taking adjournment without praying for any stay order and seeking for implementation of the order. So, Lord, I am humbly praying, Lord, let the matter be posted after vacation, but let the contempt, Lord, be stayed. This is pertaining to, Lord, overtime allowance of the attendance of AC coaches. That matter, your Lordship.
That is a decided issue.
No, they relied on Bombay High Court division bench, which was SLP was taken out from Bombay High Court. SLP was dismissed without observing anything. Now, Lord, I am relying on a Kerala High Court division bench. That goes against him.
Maybe. Then let us hear it right now. So what? Kerala High Court division bench, when Bombay High Court judgment has been tested up to the Supreme Court, will rely on Kerala High Court.
No,
Let us see
Kerala High Court
what the judgment is.
said that.
Let us see then. We'll consider.
Kindly see the
Yes.
Kerala High Court division bench.
Yeah, unnecessarily filing these matters. We have passed a judgment in one case. We have also dealt with this issue.
But actually, they did not work for the whole time.
All these arguments have been considered. All these arguments that they are allowed rest time. They are not working continuously. They are working.
No,
Same thing in every case you will raise.
No, the Kerala High Court has said, Lord.
So, all right, that is the only additional thing that has to be
Yes.
considered. That is nothing.
So I'm placing the judgment of the Kerala High Court.
Yes.
That is the only thing which I can rely upon. Nothing more, nothing less.
So where is our judgment which we have passed? They are claiming parity with loco pilots.
Yes. Yes.
You are appearing in that matter. In that matter, you are appearing. Can you give us our judgment? And this judgment has not been challenged.
Lord, I have instruction, no challenge has been made as yet.
Tell us, first you tell us.
Because Lord, I sought for instruction because I communicated everything about your Lordship's view. Lord, they said that this was never placed.
We are asking about today.
Yes.
We are asking about today.
Yes, Lord.
Whether till today it has not been challenged.
Till today, Lord, I do not have any information. But I'm saying, Lord, back 1 month. I'm talking about 1 month.
That's
back.
a long time.
But it is a judgment of 14th day of March 2024.
That we have seen. That's why we are saying. That is why we are saying. Because you will not file the SLP. You will only come to know when the notice is served.
That's correct. Lord. So, Lord, what I am on, Lord, kindly keep seat after vacation.
No,
Lord.
no, sir. We are not inclined to stay. These issues, once it is decided, there should be no stay.
Lord, diverse judgments, your Lordship kindly consider diverse judgments by
No
different.
diverse judgment. There is no diverse judgment. There is one
because
judgment.
Bombay said something.
Not Bombay, sir. Don't peg it at Bombay. That Bombay judgment SLP has been dismissed.
That's correct. But here the
Therefore,
Kerala High Court said, Lord,
so we are
the
willing
case
to
to case
consider.
basis, Lord,
Give us, where is the Bombay High Court judgment?
Kerala High Court, Lord, said that case to case basis.
We have seen. They say, tell us how you have worked overtime. Nobody asked the loco pilot how they have worked overtime, but they will ask the AC mechanic how they have worked overtime. That is the only issue.
That's correct.
Where is the Bombay High Court judgment?
Bombay High Court. Petition petition
What happened on 8/7/25 before the tribunal?
Lord, the matter could not be taken up. It has been posted to some other date, Lord.
What is
28th October, as I am told, Lord. 28th October.
28th October. It will be fixed on 28th.
এখানে বোম্বে হাইকোর্টটা বের করে রাখ।
So we are keeping it on 27th. So towards the judgment of the Bombay High Court.
27th, Lord.
What?
Lord, I may not be available. Lord.
No, he will be
No,
here.
4th November. Lord.
Somebody, no, not after 28th. 24th, 27th or 28th. Which date do you want?
27th is a Monday, huh?
Yes.
All right, Lord. Let it go.
As none of You are appearing.
So I'm extremely grateful. No.
Keep this on record. Keep this order on record.
My lord, 18, I am for the respondent, my lord. 18, I am for the respondent, my lord.
Why so early? Why so early?
I was engaged in another court, my lord.
We have adjourned the matter. Why you are not appearing here and there you are making submissions? We have kept it on 27th October.
Okay, okay.
Send someone to give your appearance. 27th.
Hmm.
27th.
My lord, regarding item number 19, my lord, I am late by the learned ASG, my lord. But my lord, due to his back pain problem, my lord, he has not able to come today, my lord.
What do you want? What do you want?
My lord, next week, any day, my lord.
We are informed by Mr. Swenso, learned advocate.
And 20. Starting 20. Truth. What do you mean? Answering this.
What a time name is.
Your Lordship, I
अभी कोई स्कीम नहीं थी
Your Lordship, I want to take 1 week of adjournment of this matter.
Respondents 2 and 3.
But I appear for one, Union of India. I appear for Union of India.
And you are for?
I am familiar 2 and 3. Answering respond National Small Industries. They want compassionate appointment. Your Lordship.
No scheme.
No scheme.
Earlier also we have adjourned it. You are not appearing. Why do you want to?
Your Lordship, my senior is having a fever, viral fever.
Fever?
Yes, Your Lordship.
This can be disposed of. When? Next week?
Next week. Feel grateful, Lordship.
Next Monday.
Next Monday. An adjournment is this will
I mean, a something issue.
21.
21 when I appear for the respondent. Well, yesterday at 5 p.m. they have served this, the petitioner. So we want to use an op.
What have they served?
So this one land losers matter.
Oh, they have served it yesterday. So we have recorded yesterday.
Yesterday when I was not there. They have at 5 p.m. they have served me this.
Whatever it is. None appears on behalf of the writ petition. Then you say list the other side of the puja hall.
And 22.
But I appear for the rest. Good. 23. Dismiss for default, and we do not have anything to get in matters which are dismissed for default.
My lord, I am appearing for the respondent, my lord. My lord, this is the land user, my lord. Yes, sir. Yes, ma'am.
But for the respondent.
Yes, my lord.
For that matter.
Yes.
Item 24. 24, my lord, I am for the petition. This matter has come wrongly. So it has to come under the hearing. That's because there is a direction of previous division bench on 21st May 2024 with a direction to file affidavit in opposition. So if kindly your lordships provide that.
And kindly see the order passed by the tribunal. Yeah. The tribunal rejected the application on the ground of delay. Order was passed in 4th January 2023 at the admission
Order
stage.
passed on 21st May 2024.
What is the tribunal's order?
Before going to the tribunal, may I say something about the fact? Kindly says that the petitioner elected for appointment in the post of West Bengal Junior Fisheries Service. That is in the year 1984 May. Then petitioner is appointed in the post of Junior Fisher Officer. Thereafter,
In 84. In 84.
in 1985, petitioner is informed to go for training. Petitioner went there and training completed and thereafter back to the service. Then in the month of May 1985, so cause was given due to absence. Thereafter, petitioner forwarded reply and then in the month of August on 8/8/1985, suspension order passed with an order of to provide subsistence allowance pending inquiry. That is available in page 33. Thereafter, in 1987, charge sheet and disciplinary proceeding initiated.
What is the date of charge memo?
That is 7/7/1987. It is page available in page 34.
On the 17th August.
7/7/1987, I find. Charge sheet. Then reply to the charge sheet was there on behalf of the petitioner. It is thereafter 26/12/1988. Petitioner intimated that subsistence allowance given, but subsistence allowance has not been provided at all to the petitioner. That is 26/12/1988, page 40 of the petition. Then again, in 2002, petitioner approached through advocate that departmental proceeding was at the stage of charge sheet, no further progress, and petitioner is suffering from suspension. There is no provision for provided subsistence allowance to the petitioner. That approach was made. Then,
which page?
It is page 41. And year November 2002. Then, as because the entire process is in silent, in the meantime, petitioner is superannuated. In the month of October 2019, an appeal through RTI was provided.
What is the date of his superannuation?
Superannuation was in the year of 2016, but I'm not getting.
31st July 2016.
31st July. But
Yes.
then an RTI appeal was preferred. It again remained silent. After preferring this deed application before this honorable court, my lord, the appellate authority informed in the appeal through RTI as was filed, and kindly since these are the supplementary affidavit I have made ready. And you see the order. It is available at page 7.
Yes. So immediately 8 years after you retired, you have got the reply.
I got reply, but I prepared an application before the.
What is it you want?
My.
What is your prayer before the tribunal? Show us from the OA.
Page 62, your lordship will find that there was a prayer for subsistence allowance to be paid that has not been paid, and as the petitioner is superannuated, but the process of the departmental processing has not been even initiated. Initiated but not ended.
So were you?
That is the process.
Were you ever put in a permanent service, or you were on probation?
No. After completion of training, well, I have been inducted, so it is absolutely permanent. It was.
That is, there is no presumption that if you have done a training.
I have annexed that document. Kindly come that document.
There is no presumption. We are asking you whether you were in probation or you were permanent. Just because you are trained, we will not presume. We are asking you what is the situation.
I was permanent.
You have said so.
Yes,
And where is this impugned order of 8/8/1985? Which page?
27, 5, page 31 is the so-called.
We are asking you where is the order of 8/8/1985?
Page 33.
So you did not reply to the charge memo.
I replied to the charge. memo.
Where is your reply?
Page 37. Yes, reply to charge. That is the annexure B5.
What is the date of this reply?
Hmm?
There is no date.
And the date was there, but not here. But it was given. And subsequently also I find that annexure P11 page 40, there was also an approach was made on behalf of the petitioner to the director. And there was also mentioned that
We don't know whether you ever submitted this annexure P10 or not, because your pleading does not satisfy us.
then I am to search from the original file whether there
You
is.
don't have to. You come to page 62. Your petitioner has chosen not to give any date.
The page 62, he also admitted that position that petitioner replied the same, controverting the allegation alleged upon him in the said charge sheet categorically by a letter through registered post.
So therefore, he has chosen not to give any date. That's why we are saying.
Whether then I have to search whether.
No, we don't want you to search. Where is the question of searching? When your petitioner does not want to give, why should you search? If he wanted to give a date, he would have given a date. He has not given a date before the tribunal. There is no date on the document. What is there to search?
Kindly come the next paragraph in the page 62 that there is also a reply and that reply.
That we are considering. That page 40 we have seen. That is nothing. 40 is saying, give me everything.
Not everything, but
Please read. Please read, sir.
It is also on the page 46.
Yes.
Third paragraph is that it is
Yes.
also informed to you that from suspension I have not yet received any amount from the office, which I have informed by meeting myself to the directorate during my suspension. My due salary have not yet been received from Balurghat.
What does he want? Please read further.
So I request you to consider my case and also to pay my all dues means have to
No, just read, sir, what he says.
and allowances along with the due salary to
He is not ambiguous. He is very clear what he wants.
It was the approach from the petitioner direct without.
So what is your submission? Therefore, we are asking.
That extent twofold. As first one is that even there was an order to pay subsistence allowance on the basis of the suspension order, but that has not been paid. And even I made an application through RTI to search out what is the position. Then the directorate replied to that RTI that file is not available. Whether subsistence, what is the positions of payment of subsistence allowance? That I have handed over to your lordship supplementary affidavit. And then next one is the departmental proceeding initiated by a church. But what is the position of the departmental inquiry? My submission is that the departmental inquiry stands abandoned. So when it is abandoned, then why if at least subsistence allowance and then other further allowances are to be available.
If it is abandoned, why at least you should get salary for your entire service period. If it is abandoned, then why only subsistence allowance? Everything, salary, pension, everything you should.
But even to that extent, your lordship kindly says I approached through RTI to the department and department says that file also locked.
That's all. That is all. Anything else? Take down.
But to that.
You have given 2 copies.
Here is your Lord Ajay Kumar Chaudhary, that is true. Citation এখানে আছে civil appeal number 1912 of 2015, 12 of 2015. Here your lordship kindly come paragraph 2015, paragraph 8, 9 and paragraph 14. But if a charge sheet is filed and suspension, my lord, thereafter charge in the suspension exceeding 3 months. It is appeal number 1912 of 2000. May I read out that part? Paragraph 8, may I read it out?
Please let us see the facts of the case. Yes. We have seen it. Para 8 you want to read.
Para 8, 9, and also paragraph 14.
Yes.
Thing is that the petitioner suffers for the long period,
Quite long, very long.
very long,
Yes.
but the
Unusually long, if we may say so.
and my submission is to that extent that the long or very long that has not been done at the petition. Suspension was there. It was the duty of the authority concerned to pay at least subsistence allowance. That has not been paid. Even from the RTI applications, as I have already handed over to your lordships, that it also signifies that the entire process of suspension and forwarding of providing subsistence allowance and thereafter the continuation of the disciplinary proceeding has not been taken care by the authority. And as I was put out of the office, so I could contact through letters and etc. May have the registration data dated has not been mentioned in the petition, but
Not only mentioned not in the petition, the letter also does not have any date.
the letter if forwarded through the registered post, so it was the duty of the petitioner as at least to mention the which registered number and date. But it does not see that thereafter petitioner approached entirely, even through the RTI. So petitioner was not make himself silent. He was approaching to the authority to take steps, but authority has completely silent about that position and did not take any chance to develop that position.
So we have understood your case. What you are saying is you are placed under suspension. You have never been paid any subsistence allowance. You have been pursuing it for 40 years, but still you have got nothing. This is your son. Yes.
I see the imperial order passed by the learned tribunal.
Yes. We have not seen the order of the tribunal yet.
Yes. Why the application has been he challenged the order of suspension 8th August 1985 in 2023. There is no and prayer in the page 65 in the original application, page 65.
65.
Yes.
We have seen the prayer, not 65.
Consideration of the order passed by the Director of Fisheries, Government of West Bengal, by memo dated 8th August 1985.
And what are the other relief?
Direction of concerned authority to de novo consider the case of the applicant for sanction of leave of medical ground, which is main allegation against the applicant in notice by the director. Part of the authority director considered when on 8th August, the concerned authority issued an order of suspension. All along, his case is that I have been suspended in 1985, case challenge in 2023. Under section 21 of the Administrative Tribunal Act, maximum 1 year, 6 months and 1 year.
So his last representation is of which date?
And he did according to page 66, retired on 1st July 2016.
Huh?
According to page 66, prayer Roman 4.
Can you say that again, please? What are you saying?
Page 66, prayer Roman 4.
Yes.
Direction upon the concerned authorities to sanction the retirement benefits, namely pension, gratuity, along with all salary, including interest for the applicant on superannuation from service with effect from 1st July 2016. From 1985 to 2016, she has waited. He could have challenged in 1986, 87, 88.
What is there of 2016?
2016, he retired at the age of superannuation.
What is the last date of representation?
And that is available at page 52, 24/6/2022.
54.
52.
So the lawyer notice.
That was the finally no option was there. And further, may I submit one thing, my lord?
Yes.
And 22 to kindly consider the supplementary affidavit given. As I made application through RTI in the year 2019, what is the status? Please tell me. And while this petition is filed before this court and an initial order was there, then directorate forwarded the reply to that RTI application saying that files are not available.
Yes, you have already given us the supplementary affidavit. That also it is by the appellate authority. That also by the appellate authority.
By the appellate authority. Kindly see that the first, may I just read it out, page 7 of the supplementary affidavit.
Yes.
Subject is there, reply to the RTI petition dated 21/2020. And when this is given? This is given in the year 24.
After 3 years.
After 4 years.
4 years.
If that position even brought to my notice, I could also develop this way application there. This is the opportunity also I have lost.
And where is the charge memo?
Charge memo at page 44. 34.
All these documents you have annexed before the OA. They were not part of the OA.
Everything was there, but the tribunal has not considered entirety, considered only the order, that is suspension order, and then dismiss this.
No, there is no such pleading about the charge sheet.
Page 62, there is reference of charge sheet.
Paragraph 6.9. 6.9.
Yes, 6.9.
Charge sheet has not been challenged before the term. Only suspension order has been challenged.
No, kindly see the other part of the prayer. Prayer 3, page 66.
Charge sheet has not been challenged before the term.
He has not participated in the proceedings. He has not even given a reply.
The reply has given.
That we'll consider whether it can be taken to be a reply or not. We are being very clear. We don't consider it a reply. We will not.
But your lordship's kindly see even subsequent representation, they are also mentioned.
Sufficient times you have said that.
That-
Subsequent representation and RTI.
One thing I may draw your lordship attention, if there is a direction to file opposition, if there is any opposition, then state authority can also put it to that extent that I'm not 100%.
See, unless you make out a case which inspires confidence, why should we ask them to reply? Not required.
And because your lordship is on the point that whether I forwarded reply.
So therefore, we are saying unless your pleading inspires confidence, you have just an extra typed copy saying I have submitted it. When you have submitted it, nothing is there. And you want the court to accept that you have submitted it.
To that extent,
Cannot be.
Can you provide a chance so that I will?
Sorry, not now.
First. And second thing,
Not
your
now.
lordship kindly see whether any document is produced by the state authority to draw your lordship's attention to that extent that there is no reply from the end.
No, we don't find it from your OA itself. We are going to record this finding. It is clear as daylight. What is required to be seen from their side? Somebody who is suspended in 85, he moves the tribunal in 23. And now you want the state to search out the records and make out a case for you.
No, it is.
You have not made out any case.
My lord, your lordship kindly sees that it is from the inception, the file has not been brought into the right.
All right.
And second thing, your lordship kindly considered that there is an order to pay subsistence amount.
Yes.
So it is duty of the authority.
Yes, they have all the duty.
Not done when I repeatedly draw attention to the authority, even from the year 1980.
How many repeated times you have done it?
At least 3 or 4 occasions.
4. Show us 4, please.
1988.
Show us which document. Show us the 4 documents.
I am coming one after another.
Yes, show us.
That your lordship kindly sees that there is an intimation from the part of the.
So page 40 is one. Where is the second?
Second one, your lordship will find it is in the page 41.
Yes, this is of
November
2002.
2002.
Yes.
Again, there is a 2022.
Yes.
But in the midst, what?
So therefore, these are 3.
These
These three are spread over the period in between 1985 to 2022.
Even your lordship kindly sees.
Wonderful.
And because I am in also doubt what is the
Yes,
petition.
you have in
So,
grave doubt.
I put to that.
In fact, we have not seen any petitioner so doubtful till date.
Your lordship kindly sees that.
We have yet to see any petitioner so doubtful.
What is the position I forwarded to RTI application? And what?
Please don't. Sufficient times you have said about the RTI. You need not repeat the same thing again.
So that I continue the approach one after another.
That's all then. That's all. Yes, take down. Third learned advocate for the
25.
Yes, ma'am. Appear for the Union of India. I am for the respondent, my lord. Is this petition filed by the Union of India? If you involved, my lord, is very.
You are for the writ petitioner.
Involved is very small, my lord. The
Now you are appearing. He is appearing. You are appearing.
I am for the respondent. What are
Recovery. The recovery is an issue.
Yes, yes.
How long they have been paid?
My 2.5 months. Salary, my lord, paid by that
Only
time,
2.5 months.
1 lakh something. The amount is, my lord,
159.
59,470. And COVID period, he absented without taking permission, and it was paid. Subsequently, there was a circular. According to that circular, my lord, it should be recovered. And relying that circular, my lord, after scrutiny, my lord, the authority issued notice and for recovery. That he challenged before by filing an away. My lord, the tribunal relied on 2 judgments of the Honorable Supreme Court. That is prior to, that is not at that point of time, the COVID circular was not there, and this was not subject matter. So, my lord, that 2 judgment relied on by the tribunal is not applicable in the facts of the present case. In the facts of the present case, my lord, it should be considered whether, in view of the notification, the applicable in the facts of the case, and if applicable, recoverable or not. But the notification is at page
So can such recovery be made from the DCRG? Permissible? Under which provision? After retirement,
yes,
such a recovery can be made from the DCRG.
But your lordship is raising a point, my lord, whether death come retirement benefit, whether from that account it can be deducted or not. That
Or any, where is the order on the basis of which the recovery has been made?
your lordship kindly page 21. This is the circular.
No, but he has retired in 2020.
Yes, and the absence period is also, my lord, of 2020.
Has to be prior to his retirement. So, but then when has the recovery been made?
Recovery has not been made, my lord. The notice issued.
When? Show us that notice.
Yes. That is, my lord. Page 33. 15 July 2021. My lord has got.
Can you read it, please?
Pardon?
Can you read it?
No, that is my lord. I have also asked him, my lord, to provide me type copy so that it's difficult for me also. I have today also I have written.
As per attendance, he was absent from period.
No leave has been. একদম আমি লিখেছি ওদের যে এটা this is not expected. বোঝাই যাচ্ছে না কিছু। কিছু করা যাচ্ছে না। No leave has been sanctioned to the said competent authority by the competent authority. Say
So in this way, can it be recovered by such a letter?
your lordship is and I have to take my lord, whether DC urged it.
No, for many things. Once a person has retired, the master servant relationship is over. Can you make such a recovery from anyone after retirement?
If it is paid, my lord, by inadvertent mistake, and it is found that, my lord, in view of the circular, it should be recovered. In that event, my lord,
So let us see under which provision.
So that is the circular, my lord. The circular is, my lord is posing the question.
That circular which you have just placed.
Yes.
Yes.
21.
Yes.
Page 21.
Yes.
May I place the circular?
Yes. This is regarding regularization of absence. This is not regarding
My
recovery.
lord, payment. My lord, your lordship your lordship will find the second paragraph. It has been noticed that different zonal railway are following adopting different procedure for regularization or absence of railway employee during COVID-19 epidemic lockdown. In view of this, it has been decided to adopt uniform interim procedure order over Indian Railway with a view to maintain and update leave records as per extant procedure. Therefore, it has been decided to regularize the absence COVID period pandemic lockdown period as per following measures for only those situations which have not been covered under the above mentioned DOPT letter dated such and such as an interim relief measure. Still further clarification is received from the DOPT. My lord, the next page, my lord, it comes under serial number 17. 7. Serial. He absented himself without permission.
Absent the period and decided as per normal rules. After retirement,
Normal rules means, my lord, had this circular was not there and he has absented. My normal service rules were.
all this circular is there, you have to refer to the normal rules. Said the period may be decided as per normal. It does not say any special for this COVID period. You can just write a letter and
As per that circular, it should be recovered, but as per normal rules. Normal rules provides for recovery. If a person, an employee paid excess amount, that should be recovered under the normal rule. And that is why, my lord, I can, if your lordship asking, my lord, I can produce your lordship the non. What is the normal rule your lordship is?
Unless that provision cannot be without natural justice, that you will issue a letter that
And your lordship is, and your lordship is posing to question to me, my lord. One
if he is in service, this cannot be done.
I follow, my lord. Your lordship is posing to question to me, my lord, whether what is the normal rule and whether the authority
How do you justify this letter?
Authority of recovery.
How do you justify this letter? The tribunal, what is wrong with the tribunal's finding? That we are asking.
Tribunal's finding, my lord, tribunal relied on two judgment of the year 2022, my lord. Your lordship kindly produce the tribunal's judgment.
Rafiq Masi is of 22.
I tell you, lordship, prior to COVID period. And this is my lord 2014 judgment. In page 14.
Much earlier.
Much earlier. So,
22.
My 2014, my lord. Para 6, my lord, internal page 4, para 6, your lordship will find, my lord, that this is the judgment of 2014. So, at that point of time, my lord, this issue was not there. In that judgment, it was considered in what circumstances, how it can be recovered or not. But this is not applicable in view of the circular of the issued during the COVID period. I can come up with
Date of the letter.
Oh.
Oh, here is 2721. Letter is clear. So that letter has been quoted in the tribunal's order. Is clear. At page 2, bottom of the page 2.
normal service rule, whenever an amount is paid.
So this judgment that the tribunal has relied upon is not applicable. That is yours.
That is.
Yes, take down. Or learned
Item number 22, my lord, dismissed for default, my lord. Item number 22, my lord, dismissed for default, my lord. My lord, Lordship, kindly, Lordship, senior, due to my fault, my lord. My lord, Lordship, senior citizen, my lord, bedridden condition, my lord, Lordship. So this is my fault, my lord. Lordship, if your Lordship, kindly, my lord. Lordship, kindly, yes, my that. My lord. My lord, this is my fault, my lord. From 3 p.m., my lord, all the, my lord, division bench, single bench, and for that reason, my lord, I missed them. My lord, from 2:37 to here, my lord. Lordship, kindly, my lord.